Welcome back to City Education, your home for education in all forms, shapes, and sizes. Today we are diving into the fascinating world of trademarks, specifically focusing on Section 34 and Section 35 of the Trademarks Act. These sections are crucial for understanding what constitutes trademark infringement and how well-known trademarks are protected. Section 34 of the Act outlines what constitutes an infringement of a registered trademark. Essentially, it protects the rights acquired by registering a trademark. Let's break the three main types of infringements under this section. Firstly, we have identical goods or services infringement, covered under Section 34, subsection 1, paragraph 8. This first type of infringement deals with situations where someone uses a mark that is identical or very similar to a registered trademark for goods or services that are identical to those of which the original trademark is registered. The key here is the likelihood of deception, confusion. Now, imagine a registered trademark for Super Clean laundry detergent. If someone else starts selling Super Clean with a K laundry detergent, that's likely an infringement because the marks are very similar and the products are identical. The public would most likely get confused. In order to determine such an infringement, you'd need to identify firstly unauthorized use. This is where the person uses the mark without permission. After which, you'd need to establish that they are using such a mark for commercial purposes. Then establish that the mark is the same or very close to a registered mark. After that, check if the goods or services being sold are the same as those covered by the registered trademark. Then, last but not least, this is very crucial. Check if the consumer would likely be confused thinking that the product is from the same source. Now, think of an image of a Kappa shoulder bag. If Kappa is a registered trademark for bags and another company sells a bag with an identical or very similar logo, presenting it as a Kappa bag, that would be a clear example of this type of infringement, especially if it's not an authorized product. Even if it's a parallel import, if it's not genuinely from the trademark holder or authorized distributor, it would be an infringement if it causes confusion. And a clear example of this is a certain place in Joburg called Small Street, but we'll get into this another day. Moving on to Section 34, subsection 1, paragraph B. This addresses situations where the mark might be identical or similar, but the goods or services themselves are only similar, not identical. Again, the likelihood of deception or confusion is paramount. Let's go back to Super Clean laundry detergent. If someone then starts selling Super Clean dish soap, the products aren't identical. One is for laundry and the other is for dishes, but they are similar household cleaning products. If the mark is similar enough, it could still confuse consumers into thinking the dish soap comes from the Super Clean laundry detergent company. Now, the elements to look out for are similar to the ones in Section 34, subsection 1, paragraph A. You'd need to look out for unauthorized use. Secondly, in the course of trade, meaning commercial use. Thirdly, how identical or similar the mark may be. Fourthly, how similar the goods and services are. And last but not least, the likelihood of deception or confusion. Now, imagine a well-known car brand, Lion Motors, which has a distinctive lion logo. If another company starts selling Lion car polish with a very similar lion logo, even though the car polish isn't a car, it's a related product, consumers might assume that the polish is endorsed or manufactured by Lion cars, leading to confusion. Now, the third aspect is the dilution of a well-known trademark, which is covered under Section 34, subsection A, paragraph C. This is a crucial aspect of trademark law, especially for strong brands. Section 34, subsection 1, paragraph C, protects well-known trademarks from dilution, even if there is no confusion about the origin of the goods or services. The focus here is on preventing unfair advantage or detriment to the distinctive character or reputation of the well-known brand. Think of a globally recognized brand like Coca-Cola. If someone started selling Coca-Cola dog food, consumers probably wouldn't think it was made by a drink company. However, such use could still harm the distinctive character or reputation of the Coca-Cola trademark, or even unfairly benefit from its fame. This is dilution, weakening the brand's unique association. Now, let's break down the elements for dilution. Like the above two, you'd need to look out for unauthorized use and the course of a trade, meaning commercial use. Then you'd have to check if the infringing mark can be used in relation to any goods or services regardless of similarity to the registered mark. After which, you'd have to check whether the infringing mark is the same or very close to the registered mark. Another important element to look out for is whether the well-known or registered trademark is well-known in South Africa. Another element to look out for is whether the use of the infringing mark would likely exploit the repute of the registered mark or harm its distinctiveness. Last but not least, you have to check for the absence of confusion or deception. Now, this is a key differentiator. Even if the consumers aren't confused, dilution can still occur. Now, consider the Nike swoosh logo. If a small unrelated business decided, let's sell swoosh brand garden gnomes. Yes, consumers wouldn't confuse them with Nike shoes, but the use of the swoosh could still take unfair advantage of Nike's reputation or diminish the distinctiveness of the iconic logo. Beyond registered trademarks, Section 35 provides protection for well-known trademarks even if they are not registered in South Africa. This is largely due to South Africa's obligations under the Paris Convention for Protection of Industrial Property. This section is for big international brands that are famous worldwide, even if they haven't gotten around to registering their trademark in South Africa yet. If someone tries to copy a well-known mark, Section 35 offers a way to protect it. For a well-known trademark to be protected under Section 35, the following conditions must generally apply. Firstly, the mark must be well-known in South Africa. Secondly, the owner of the well-known trademark must be from a country that is part of the Paris Convention. Thirdly, the infringing mark must be a copy, imitation, or translation of a well-known trademark. Fourthly, the offending mark must be used for goods or services similar to those of the well-known trademark. Number 5. The offending mark is being used or must be used for a particular trade. Last but not least, the use of the offending mark should likely cause confusion or be deceiving to consumers. Now, imagine a luxury fashion brand like Gucci, which might not have every single one of its trademarks registered in South Africa, but is undoubtedly well known globally. If a local manufacturer started selling bags with an identical or very similar Gucci pattern, while Gucci is from a Paris Convention country, they could seek protection under Section 35, especially if the local product is likely to cause confusion among customers or consumers. While the Act outlines what constitutes infringement, there are also a number of potential defenses available if someone is accused of infringing a trademark. These include good faith use of own name, which is essentially using your name in good faith. Then we have good faith descriptive use, which is basically using a term descriptively in good faith. After which we have good faith use to indicate intended purposes. which is essentially using a mark to indicate the purpose of a product in good faith. Then we have use on genuine products. This is if the product itself is genuine. After which we have good faith use of utilitarian features, basically using functional aspects of a product that are not protected by the trademark. After which we have use to which the registration does not extend. This is if the alleged infringement falls outside the scope of the trademark's registration. Then we have concurrent registration. This is if both parties have valid coexisting registrations. And the most famous one, we have estoppel. This can also be a defense, essentially meaning that the trademark owner is preventing the other owner from asserting their rights due to their previous conduct. So, if a trademark infringement is suspected, what process or procedure can one use? Well, if there is no dispute of facts, an application procedure can be used. This involves filing a notice of motion and a founding affidavit. In the case where there is a dispute of facts, an action procedure can be followed, which involves summons and particulars of claims. In cases where there is a genuine fear that the infringer might destroy or remove evidence, an Anton Pillar order can be sought. This follows the attachment and removal of evidence until the case is finalized. And that wraps up our overview of Section 34 and 35 of the Trademarks Act. Understanding these provisions is vital for both trademark owners and those operating in the commercial world. If you have any other questions, place them in the comment section and we'll get back to you. This is City Education, your home for knowledge in all forms, shapes, and sizes. Don't forget to like, share, and subscribe. Until the next video, goodbye.